Sir, are you Mr. Glover?
Good morning, yes, sir.
All right, good morning. This is against State of Ohio versus Christopher J. Glover, 2025 CRB 01202. Let the record reflect the defendant is present, not represented by counsel here today. Mr. Graham is here on behalf of the State of Ohio. This matter is set before the court today for a clear trial setting on two charges. First is menacing by stalking, and the second is illegal use of a tracking device. Mr. Glover, is it my understanding here today that you do not have counsel, is that correct?
Yes, sir.
Are you asking for a continuance in this case in order to obtain counsel, or what is your?
I don't qualify for a public defender, and I don't have 10,000 for a lawyer, so I'm going to have to go on by myself.
Okay.
No choice.
All right. So here's typically how that's going to work. So, Mr. Glover, I heard you indicate that you've already attempted to apply to see if you're entitled to public defender representation. You indicated you cannot. I also heard you say in that same statement that you can't afford private counsel to obtain private counsel. And so typically what we're going to do, I'm going to let Mr. Graham kind of put on the record to the extent has discovery been completed, Mr. Graham, for this case?
From my review of filing on discovery is not been requested.
And so Mr. Glover, what you're probably going to want to do is there's going to be some things that you're going to want to file. You picked up on that fairly quickly, okay? And so you have a right to represent yourself. That is a constitutional right that you have. I would just warn you that you understand this will ultimately be set for either a bench trial or a jury trial. Understand that a jury trial is something that you would have to request in writing, and that has to be filed with the corporate courts prior to that date and time. What I'm seeing here is this was a fairly new charge. The allegations and complaints filed were on May the 17th of 2025 by the Pierce Township Police Department. So as such, understand that menacing by stalking charge is a misdemeanor first degree. Illegal use of the tracking device is also a misdemeanor first degree, whereas you could be sentenced up to 180 days for each one of those counts in the Claremont County Jail. And so if you are intending to proceed forward here today for a trial, I have a feeling the state of Ohio is not prepared for that. And so if your request is to set this for a bench trial with the court, you could make that request here today. If your request is you want to set this for a jury trial, then you'll need to go out the doors, down the hallways to the clerk's office, and there'll be some paperwork that you need to file as that request. Otherwise, because you, as you stand here today, you're not represented by counsel, you just need to tell me what your intentions are as it relates to moving forward with this case.
I'll have a motion for discovery, of course, and I guess we'll go on trial.
Okay. All right, so what I'm going to do is I'm going to set this case out for 2 weeks, okay? And in order for you, Mr. Glover, to continue to explore your options. It doesn't appear that this is your first clear trial setting. Looks like you were in front of the court on June the 13th. As such, what we're going to do is I'm going to continue this 2 weeks in order for you to file anything that you believe you need to file on your own behalf here today. And then we'll see you back in 2 weeks. And if at that time you've received what you believe you need to receive and you're prepared to go forward with the trial, you'll be able to do so at that time. Okay. Any questions, Mr. Glover?
Have you filed for the motion to discovery to see the clerk?
Correct, sir. Before you leave here today, however, there is one thing that I need to go over with you here today. So understand the state of Ohio only has, now even though you're not incarcerated, the state of Ohio has what's called speedy trial time. So because there's a continuance here that you're requesting in order to obtain discovery and do some pre-trial matters, I am going to ask that you sign off on this continuance. There'll be a section here where it indicates that you are waiving any speedy trial time as you await for your next hearing. Do you have any objection to signing that today, Mr. Glover?
What is that for, speedy trial?
So again, the state of Ohio has a certain period of time for each case to be brought to trial. Okay. And so that's constitutionally in the law. So you're not incarcerated. Okay, so you have 90 days.
90 days. I haven't checked to see if the jail time counts.
Were you incarcerated on this charge?
Overnight.
Okay, so 1 day. All right. So at this point, Mr. Glover, it's not an issue. The court has to keep track of any speedy trial time. That's accumulation. In this particular case, it sounds like I don't have to be concerned about getting you a speedy continuance. But as a matter of practice, what we would typically ask you to do is to waive any speedy trial time for the next 2 week continuance for the next hearing. Do you have any additional questions about that?
No, sir.
All right. So there'll be a place for you to sign and then a place for you to initial when available, bring that to you. Mr. Grauman will also sign that on behalf of the state of Ohio.
Your Honor, this may be on the form, so I may be getting ahead of myself, but we said this for a clear trial setting, correct?
It's going to be a clear trial setting.
And then determining.
Correct.
Thank you.
Yeah. I don't remember Mr. Glover being from me, so that's why I wanted to explain some of this to you today, sir. And then once you file any pretrial motions that you believe we want to file on your behalf, my intention would be at the next setting. You can tell me how you wish to proceed forward on this case. But I'm going to set this for a clear trial setting, which is a setting just like you had today. Okay, so we can come back to the court to have a discussion maybe about the next steps in the process as it relates to this case. Before you leave, Mr. Glover, make sure you go out the doors, down the hallway, check in with the assignment window. They're going to give you the next date and time for your hearing. It's very important that you continue to be present for each of your hearings, otherwise the bench will be issued for your arrest.
We don't want that.
All right, thank you, Mr. Glover.
Thank you. Have a good day.
Our next case will be State of Ohio versus Prince Walker. This is 2025 TRC 03074. Good morning, are you Mr. Walker?
Yes, sir.
Hi, good morning, Mr. Walker. This is State of Ohio versus Prince Walker Jr. 2025, again, TRC 03074. The defendant's present, represented by counsel, Mr. Mason. Mr. Brown is here on behalf of the State of Ohio. It appears that this matter is set before the court today for a as it relates to this case, Mr. Mason, he received a copy. It looks like this was continued on June 9th, 2025. Sentencing was continued for a cask evaluation. Have you received a copy of the cask evaluation, Mr. Mason?
I have not, Your Honor. I would be able to,
Would you like to
verbalize it, but,
Yeah.
all right, sure. Thank you.
Did you need to speak to your client, Mr. Mason, after reviewing the cask evaluation?
No, Your Honor.
All right, very well. As it relates to mitigation in this case, go ahead, Mr. Mason.
Your Honor, Prince is 37 years of age. I believe he did have an OVI conviction in 2016. It's been, I guess, approximately 9 years ago. On this occasion, there was a crash. He was taken to the hospital, suffered, I guess, some significant injuries, but he's in good order now. Your Honor, I've explained to him he's going to have to at least satisfy the mandatory statutory sentence. He's prepared for that. As far as cask, I think he's going to be compliant with whatever counseling or programs the court has ordered. The main thing for him, he has 4 children. His girlfriend has 6 children, not his biological children, but frankly, he's trying to provide some support for 10 kids. He was working as a temp before the car crash, driving a forklift. It was a good job. He's looked into it. He believes he can probably resume that job as soon as he's finished with whatever jail time he had to serve on this case. There was he was behind on the child support, and there was a suspension of his license, I believe. That was the only impediment to him driving. The car he was driving wasn't insured at the time. I've explained to her that most likely the court would not be willing to give him driving privileges until he actually has an insurance policy on himself for driving. I take it you would probably start with your sentence and then come back at the appropriate time and request driving privileges. And at that time, hopefully, you would also have his work, his occupation back in mind, and then would have the need for that. As far as any special needs, any kids, anything that you would have to transport them to doctor's appointments? What? Okay, what would that be?
Using it in school.
Okay. Okay. And do you have any doctor's appointments in as much as you were somewhat injured in this crash? Okay. Anything I'm leaving out here, Mr. Walker?
So, Mr. Mason, what I'm actually going to do is I'll give Mr. Walker an opportunity to speak as to mitigation. Are you finished with your mitigation?
Yes, sir.
All right. Mr. Brown, on behalf of the state of Ohio.
Your Honor, it looks like the only other fire over the eye was from 2016. There are some associated driving suspensions. I can't, I haven't broken it down yet with those. They were not charged with OBI suspensions. And it looks like there were some child support suspensions on there, confirming what Mr. Mason said about the child support issues creating the driving under suspension charge. But other than that, Your Honor, would ask to adopt the CAS recommendation for the board.
All right, thank you, Mr. Brown. All right, Mr. Walker, on your own behalf here today, prior to sentencing, what would you like to say on your own behalf, if anything?
I had a chance to find him accepted into the CAS. I have my daughter's birthday on July 2nd, my grandmother's birthday on the 4th, and on the 12th, the funeral, and my lady lost a family member, so I could go into the CAS. After that, maybe just keep my honor on, still come weekly to check my PO, because I'm clean after me, my drug testing, alcohol testing. By chance, I can just do that.
I guess effectively he's asking for a spray run, and he hasn't had any issues with the spray meter, correct?
Mr. Walker, was there anything else you wanted to say on your own behalf here today prior to sentencing? I have a couple of questions for you. Can you tell me a little bit about what exactly was going on back on March 23rd, 2025?
It was my brother's birthday. I lost my brother in 2011. So the night before that, I was drinking and watching game time before the playoffs. That morning, I went to church with my musician at church. The other church was to go get my mother some fish in the store and lost control of the car. And it was raining, so that's what happened.
Mr. Grumman, has the state of Ohio complied with Marcy's law as it relates to understanding this was an injury car accident? Was this a single vehicle? Was the defendant that was injured, or was anybody else injured as a result of this accident?
We'll give just 1 minute to confirm that.
Please. Thank you. Mr. Mason, while Mr. Brown is looking that up on behalf of the state, can you tell me, has Mr. Walker spent any time incarcerated on this particular charge?
I don't believe so, Your Honor. He was taken straight to the hospital. When that was resolved, I believe he was just merely summoned as to arraignment on this.
Your Honor, it appears that this was a single vehicle accident. Some other parties were involved.
Is that your understanding today, Mr. Mason? There were no other victims in this case?
Yes, sir.
Nobody else was in the car with the defendant?
Not that I'm aware of.
Mr. Walker, I heard you say that this was something that happened, it sounds like, to a social event. Is that my understanding? You were watching a basketball game
Yeah, that's at home.
at home. Okay. So what caused you to drive? Were you driving home?
No, sir, I was already at home, but that morning, I just went to church, I came home, went to get my mother's fish, lost control of the car.
Yeah, he was watching the night before, I guess Saturday night. He did consume some alcohol at that time. He gets up the next day, goes to the church where he performs music. He did that, and then he was going to the store for his mother, and he lost control. I'm assuming is, as far as alcohol levels, you know, he did go to the church, he did perform. So I'm not thinking it was exceedingly high level.
The defendant refused field sobriety tests, is that my understanding, Mr. Mason?
Your Honor, there was an interview while he's lying in the ER. There's an officer standing there trying to ask him questions. There are nurses milling around. He's got family members there. So as far as whether it's a refusal or not, it's sort of hard to see that as a refusal.
The 2255, just let the record reflect, 2255 is marked as refused.
Right. Well, I think any time an officer is unable to achieve some kind of urine screen, blood screen, whatever, they tend to mark it refusal. You know, watching it, I don't think he really ever verbalized that he was refusing, but they marked it as such.
Mr. Walker, have you ever received any substance abuse assessments in your treatment?
No, sir.
All right, the court has considered for the purposes and principles of municipal sentencing and is going to sentence you as follows, Mr. Walker. A couple of factors the court's taken into consideration is it sounds like you have a fairly limited driving record in the sense of other traffic violations. I think the situation you find yourself though in is that this is a second to 10. So you had a conviction in 2016, and this occurred on March the 23rd, 2025. Understand, as it was discussed at you with the previous hearing, the court has minimums and maximums as it's associated with this particular charge. So the sentence of the court is going to be as follows. I'm going to send you to Claremont County Jail for a period of 175 days. I am going to suspend 165 of those days, which means you are going to be taken into custody here today. I am going to place you on 2 years of reporting probation. During that period of time, we're going to have I'm going to talk to you here in a second about what that's going to look like. I do want you to contribute, and I want you to participate in 60 days in the CAST program. So once you're released from custody after your 10 days, you will then released over into the CAST program. That's not incarceration, okay? It is housed in the Claremont County Jail, but you will not be in the custody of the Claremont County Sheriff's Office. You will be required to complete 60 days in the CAST program. Once released from the 60 days in the CAST program, I am going to have you complete a substance abuse assessment and GCBH, when that's the Greater Cincinnati Behavioral Health, and you are going to be ordered to follow their recommendations. I'm going to have you contribute 16 hours of community service that I want you to complete within 60 days on the work crew here in Claremont County. That will be picking up garbage along the roads or any other jobs that they're working on that particular day. I'm going to suspend your license for a period of 2 years. You are not to have any driving privileges unless further order of this court. I heard a request being made for driving privileges here today. Mr. Mason, your inclination is correct. The court is not going to entertain any driving privileges at this time. As it relates to that request is therefore denied. I will credit the suspension back to the date of the offense. This offense took place on March the 23rd of 2025. I will allow that to be credited back. This falls under the old statute. The new statute took effect April 9th of 2025, so I am going to issue a fine of $525 plus your court costs. All right, Mr. Walker, as it relates to your time while on probation, I'm Again, we've discussed the fact that while you are in CAS, you've got to complete that program. I want to emphasize to you, sir, that there are very strict rules in the CAS program. And so I'm going to mark as part of your probation that you're required to complete 60 days, and you're required to follow any rules within the CAS program. What that means, sir, is in the event that you were to be dismissed or discharged unsuccessfully from the CAS program, that would then be considered a probation violation. While you're on probation, you are ordered not to consume any alcohol, illegal drugs, and that does include marijuana. I'm ordering you not to enter any establishment whose primary source of income is derived from alcohol sales. I am ordering you to successfully complete the substance abuse treatment at GCBH as directed. Additionally, if for whatever reason, because your probation officer is going to get to know you much better than I do, if your probation officer determines that there's additional counseling that would be helpful for you, you are going to be required to complete any additional counseling that may be recommended by that probation officer. If they believe that it's important for you to attend sober support meetings, you will be ordered to do that. Just because I'm telling you this, Mr. Walker, does not mean that that's something you're going to be required to do. This is going to be where I'm giving discretion to your probation officer. You will be subject to random toxicology screens. And again, we've talked about the 16 hours of community service. If for whatever reason, while you're on probation, your probation officer makes a determination that you need electronic monitoring and or scram, my understanding is you have a scram device currently, is that correct? You would be required to wear that scram device. And again, as we've discussed, you need to complete the 60 days within the CAS program, and you're going to follow all rules as it relates to the program. Now that the court has made a sentence here today, Mr. Walker, do you have any questions about anything I've said here as it relates to my expectations of you going forward?
I think as to his request for a stay.
We haven't gotten to that yet, Mr. Mason. I heard the request made, but I'm finishing the sentence portion. So, Mr. Walker, do you have any questions as it relates to my sentence? You've indicated no, is that correct?
I was just wondering if I could get what I requested for the stay.
We'll get to that. As far as the expectations I've read to you here today, my expectations of you going forward, do you have any questions as it relates to the sentence that I provided here today?
So after the 60 days in CAS?
Yes, sir.
Mandatory.
That is mandatory.
The 10 days is mandatory, and then the judge is having to do another 60 in the CAS program.
And then it's going to be CAS?
That's statutory minimum, Mr. Walker. So understand, because this is a second intent, and I would have gone over this with you back when you entered in your plea, okay? And so understand that a second intent, and again, you're falling under the old statutory requirements, you are required to spend at least 10 days in Claremont County Jail, up to 6 months. Minimum fine, $525, maximum fine, $1,625. Alcohol and or drug assessments and treatment are mandatory. I could suspend your license from 1 up to 7 years. You're not entitled to driving privileges for at least 45 days. And I haven't gone to this, which I need to go over, is the court is required to immobilize your vehicle for at least 90 days if you were driving a vehicle that was registered in your name. So those would have been items that we went over before you entered a plea to this charge here today. Do you remember us going over that? And so you understand, you're asking a question here today as what is the minimum? And I heard your attorney indicate that the 10 days is the minimum. Okay. That brings up a point, Mr. Mason, as it relates to the automobile license in the name of the defendant in this case.
My understanding, it was actually licensed, registered to this lady in the back, her mother. Is that accurate?
Is that your understanding, Mr. Brown? While he's looking that up, Mr. Mason, I did indicate the type of probation. I am going to mitigate that to some effect. He would typically be on ISP. I'm going to have basic probation, which means you're not going to be reporting to a probation officer every single week, but you will be reporting to your probation officer at least once a month.
Thank you.
While he's looking that up, Mr. Walker, is it your understanding that the 2001 Nissan Altima orange with license plate JPM 2296, was that vehicle licensed in your name? So you don't own the vehicle? You can work on that, Mr. Brown.
And I apologize, Your Honor, I just found the answer after you confirmed that, so.
So it's understanding from the state the defendant does not own the vehicle?
That's correct, Your Honor, the owner is listed as a Felicio Ward.
All right, thank you. As it relates to the request, Mr. Mason, for the stay of the sentence here today for a period of time, I heard you indicate some of that ahead of time. Talk to me about why the defendant believes that that's something the court should entertain.
Your Honor, as I understand it, there's a child's birthday, there is a grandmother's birthday, and then apparently there's a funeral, and when's that? 12th of July. So everything would be over by the 12th of July.
Who was the family member for the funeral?
My cousin, my lady's cousin. Okay.
So the 12th of July, you would already have been released from custody, but you would be in the CATS program at that point. So I'll tell you how this process typically works, Mr. Walker. And so understand that I'm not going to grant the stay of the sentence here today based on the birthdays. Once you're in the CAS program, you would be able to make a request to attend the funeral. However, I will tell you that that's typically not at my discretion. That's going to be at the discretion as to whether or not a CAS employee is available to go with you to the funeral. They won't let you out of their sight. Okay? And so that becomes a scheduling issue for them. And so I can't answer that question as to the funeral. Okay? So I'm going to deny your request today for your stay of the sentence. You are going to serve 10 days in the Claremont County Jail, effective today. Mr. Walker, I wish you the best of luck. Understand it's important for me to emphasize to you today that in the event you were not to complete any of the terms and conditions as has been outlined here in your sentence here today, the court could make more harsh your probation, could expand your probation, or certainly you could serve the remainder of the 165 days in the Claremont County Jail. Do you understand that, Mr. Walker? All right. I wish you the best of luck, sir. Thank you.
Robert Lester.
Our next case will be State of Ohio versus Christopher Gilbert.
May I first round?
Okay.
Hear us talk.
One day and then what else? Get that, I can get it back. I said that. You wanna talk about it's recorded? Okay.
Julie Riggin.
Our next case will be State of Ohio versus Christopher Gilbert.
On behalf of Mr. Gilbert.
Hi, good morning, sir. Are you Mr. Gilbert?
Yes, sir.
Hi, good morning. This is State of Ohio versus Christopher Todd Gilbert. This is 2025 TRB 01534 and 2025 TRC 06969. This matter is set before the court today for a clear trial setting. It appears on the CRB case. This is a complaint for child endangering filed by the Ohio State Highway Patrol. And then on the TRC case, this is an OBI and a Martin Lanes violation also filed by the Ohio State Highway Patrol. Let the record reflect the defendant is present and is represented by Mr. Ferris. Mr. Grauman is here on behalf of the state of Ohio. All right, as it relates to, it appears that there's a request today. Mr. Ferris, on a continuance, go ahead with your request.
Yes, Your Honor. I was just retained by Mr. Gilbert at the end of last week. Excuse me. Filed my discovery demand this morning, so we just need some time to receive discovery and a chance to review it, Your Honor. We would ask for about 2 weeks.
Mr. Grauman, any opposition to a 2-week continuance on this case?
No, Your Honor, there was a urine test in this case, we've not received last batch yet.
It's my understanding, it looks like this is the first clear trial setting. These offenses are alleged to have taken place on June the 21st of 2025. As such, the court's going to grant a 2-week continuance. My understanding is there is a request, or there's going to be some discovery that's been requested in this case. I know urine screens are still pending, and then Mr. Ferris has indicated he's going to work on getting some other material provided to the state of Ohio for a potential resolution to this matter. Mr. Gilbert, before you leave here today, I'd like to make sure that you understand that we're going to continue this case here today. You're going to go out the doors, down the hallway to the assignment window. Mr. Ferris will probably go with you. Then you'll check in with them, and they're going to give you the next date and time for your hearing. But for today's purposes, we are going to continue this for 2 weeks for a clear trial setting. And again, I'm just going to write down Mr. Ferris as I'm just ready to go. Yes, I understand based on sidebar, there's a variety of other issues that are being investigated. Yes, sir. All right, Mr. Gilbert, we'll see you back here in 2 weeks. Thank you, sir. Next case will be State of Ohio versus Robert Luster. Again, Robert Luster. This is 2023 CRB 02147, 2023 CRB 1852. Let the record reflect that the defendant failed to appear for today's hearing. We have two charges, one a theft charge, a misdemeanor of the first degree, the second a criminal trespass, a misdemeanor of the fourth degree. The defendant has failed to appear for the hearing, and it was started at 9:47 a.m. This matter was set for the 8:30 a.m. docket.
Your Honor, I've called in the hall. There's no response. I would request continuance briefly, but I understand. Unfortunately, we don't have any phone calls or anything from Mr. Lester.
I was going to say, have you had contact with Mr. Lester, Mr. Mason?
Not today. I'm not aware.
All right, court's going to set a bench warrant at $10,000 cash.
Your Honor, I'm being told that there might be another case, Mr. Lester, in front of Judge Herbstreit.
He's on the docket
He's here.
for Judge, I don't know if he's here, but he's also on the docket for Judge Herbstreit this morning as well.
Thank you. I'm going to recall this case.
Okay, fair enough. Thank you. Megan Eichler. Brittany Evans.
Judge.
Morning.
All right.
It's Monday.
What do you think of this office? Yeah, I just, go through each of these and basically compare the batch of 90 days, he had 3 days. Three of them simultaneously, then one after another, was out of bond, both of them. So, that's, 14.
Was that?
All right, next case will be State of Ohio versus Jason Brugan. Brugan?
Brigham.
Brugan.
Good morning, Judge Mark Wazor, 0082916, Mr. Brigham. Jason Regners.
Good morning, Mr. Brugan.
Good morning, sir.
Good morning, this is again State of Ohio versus Jason A. Brugan. This is 2025 CRB 01533. Just so the record reflects, council probably were not in the room this morning, but understand there has been an application requesting permission to photograph or record these proceedings here today. So just understand that this request has been made before. You'll see this is a domestic violence case. Is there any anticipation today that any victims and or witnesses will be testifying here today?
Not testifying unless the court inquires as it relates to, the victim is here, she visited with Marcy's law attorney. We would have no objections to the defense. Thank you.
My understanding is you are Marcy's law as counsel. Is that correct?
We'll bar from that.
Mr. Parker, any anticipation that the victim plans to testify here today in this proceeding or make a victim statement?
No, Your Honor, I believe her wishes can be communicated through me as a Marshall's law attorney. So I don't believe that should be an issue.
So there's no objection to the request that's been made at the court here today in this case?
No, Your Honor.
All right. Let the record reflect that the defendant is present, represented by counsel, Mr. Resort. Additionally, this matter is set before the court today for a plea or trial setting on the domestic violence charge. Additionally, as has been indicated, Mr. Parker is here representing the victim, I believe, JP. As such, my understanding is there is a potential resolution to this case here today. Mr. Resort, is that my understanding?
It is, Your Honor.
And what is that resolution?
Thank you, Your Honor. May it please the court, it's my understanding the state of Ohio will move to amend the domestic violence charge to reflect that disorderly conduct misdemeanor of the 4th degree, we certainly waive reassurance to complain, rearrangement, any defects associated therewith. That motion is before the court as well. Thank you.
All right. Mr. Brown, on behalf of the state of Ohio, as it relates to the waiver of issuance of new complaint service and arraignment order that's before the court here today.
Yes, I mean, we've consulted with the victim. She is on board with this case. With Marcy's law, we have no objection to the amendment at all.
So, Mr. Brown, I know you're fairly new. Actually, I think this is your first day solo. And so my position on these matters, has the defendant had any other crimes of violence that have been amended in the past?
I don't believe so. Let me check that briefly, Your Honor. Your Honor, the only other thing on this record is 3 minors, 3 traffic offenses.
And Mr. Weisler, this is part of a plea agreement between the state of Ohio and your client, is that my understanding?
That's correct. Thank you.
Very well. Is that your understanding today, Mr. Bergman?
Yes, sir.
Am I pronouncing that correct?
Friggin' Brigham.
Brigham?
Yes, sir.
All right. I'll try to get that right, as I say your name multiple times. All right, so Mr. Bergen, I have a couple questions I need to go through and ask of you today. The first is, are you a U.S. citizen?
Yes, sir.
Have you consumed any drugs, whether legal or illegal, or any alcohol in the last 24 to 48 hours, which you believe would impact your ability to make well-informed, conscious decisions here today?
No, sir.
You understand that if you're on probation, parole, post-release control, community control, that a conviction of this offense could result in termination of that case or those cases?
Yes, sir.
You understand that a plea of guilty to the charge of disorderly conduct under 29-17-11 is a misdemeanor of the 4th degree, whereas you could be sentenced to Claremont County Jail for a period of 30 days and issued a fine of up to $250.
Yes, sir.
You understand that if you plead here today, you're giving up several constitutional rights that you hold. The first is the right to a jury trial, the right to have the state of Ohio prove your guilt beyond a reasonable doubt, a bench trial to be held before this court, the right to the right to present your own evidence, your own testimony, your own witnesses, the right to confront any evidence, testimony, or witnesses presented by the state of Ohio, and your right to remain silent. Do you understand those rights you're giving up here today?
Yes, sir.
You've been represented by Mr. Weiswork in these proceedings. Have you been satisfied with the advice of your counsel?
Yes, sir.
You understand the court's not bound by any recommendations that are made either by your attorney or by the prosecutor in this case?
Yes, sir, I understand.
What is your plea then to the charge, the lesser reduced charge of disorderly conduct under 29-17-11?
Yes.
Has anybody placed any pressure on you to enter into that plea?
No, sir.
Are you making that plea of your own free will?
I am.
Has anybody promised you anything in exchange for that plea?
No, sir.
Based upon the defendant's answers to my questions, I will accept this plea of guilty, and I will allow the charge to be reduced to disorderly conduct under 29-17-11. I do find that the defendant has made his plea knowingly, voluntarily, and it has been intelligently entered into. As it relates to the facts of this particular case, Mr. Weiswork, the complaint filed by Union Township Police Department on or about June 21st of 2025, do those need to be read into the record here today, or can it be stipulated?
We stipulate to that. Thank you, Your Honor.
Based upon the defendant's stipulation, as well as my independent review of the same complaint that was filed, timestamped by this court on June 22nd, 2025, the court is going to make a finding of guilty to the charge of disorderly conduct under 29-17-11. As it relates to mitigation in this case, Mr. Weiswork.
Thank you, Your Honor. My client steps forward, takes full responsibility for his actions. He'd like to apologize to his wife. This is not discussed among the judge. He is 52 years old. He has absolutely no criminal record whatsoever. In fact, his 26th wedding anniversary is coming up this Wednesday. He realizes that he made poor judgment, could have been handled completely differently. He does have 3 children with his wife. Again, noted he has absolutely no criminal record. He's working full time at Ulmer's Auto Care, which has several locations. That's located in Claremont County, in Milford, Ohio, Your Honor. We would ask that the court take those things into consideration when passing the sentence, as for a reasonable sentence, that does not include any jail time. We submit on that. Thank you, Judge.
All right, thank you, Ms. Weiswork. Mr. Brown, on behalf of the state of Ohio.
Your Honor, since the victim was represented by Mr. Parker, we'll defer to have the that.
All right, thank you. Mr. Parker, on behalf of the victim in this case, under Marcy's law.
Thank you, Your Honor. On behalf of JB, Your Honor, I would indicate, she tells me that this is nearly a 26-year marriage. Nothing like this has ever happened before. This was truly a bad night. We know the defendant is genuinely remorseful and taking responsibility. She is not seeking any incarceration whatsoever or any really punitive sanctions. Obviously, the state's deferring to the court's judgment, but on behalf of JB, I'd ask the court to consider this a period of community control.
Thank you. All right, sir, on your own behalf here today, prior to sentencing, is there anything you'd like to say on your own behalf?
I do apologize for my actions. I do love my wife, and I do whatever it takes to make it right.
Tell me a little bit about what was going on in the household on June 21st of 2025.
Sir, we've had a discussion about clutter in our house. We've had several times. It got a little bit heated, a little more than it should have. We were both throwing stuff that we need to get rid of on the ground in the kitchen, and then we exchanged unpleasantries, calling each other names basically. And then I did walk towards her after one to distance ourselves from each other. And when I did so, she stepped back at the same time and tripped over a box. And it's pretty much how the whole thing came about. We were actually upstairs talking with my son, who was around at the same time, how we could figure out how to work this out together. So it wouldn't happen again, or if it did come up again, how we could do it constructively. And the Union Township Police Department showed up.
Thank you. Mr. Parker, it's my understanding that the victim did not wish to make a statement to the court here today.
No, Your Honor, I believe she has communicated her wishes to remain and she doesn't wish to address it.
Any credit time served on this, Mr. Wexler? It's domestic violence, so there should be.
Yeah, just 1 second, please, Judge. 3 days credit, it sounds like, Judge.
Mr. Rahman, do you agree with that?
We do, Your Honor.
So there's no allegation that was made in the complaint. However, was alcohol and or any drugs of abuse contained? Were you taking anything that particular day?
No.
Okay. It was just a heated argument that got out of control.
Exactly.
All right, the court is considered for the purposes and principles of municipal sentencing and is going to sentence you, sir, as follows. The court's taken a couple of factors into consideration. The first and most importantly to the court is the fact that you have a clean criminal record. The court finds that to be persuasive. You're 52 years old. Additionally, I hear that I have a 26-year marriage. We have 3 children together, and it sounds like there were some mistakes made that particular day and time. But it's bearing upon the court the fact that you have not a criminal record at that age of 52. Additionally, it's also persuasive to the court. Mr. Parker is here on behalf of your wife here today, the victim in this case, who has indicated her wishes as it relates to sentencing this matter, which the court is additionally persuaded. Under the purposes of principles of municipal sentencing, I am going to send you to Pembroke County Jail for a period of 20 days. I'm going to suspend 17 of those days and give you credit for the 3 days that you have served. So you are not going to be put back into custody. I am going to place you on 1 year of court-monitored probation, sir, which means you are not to have any new offenses filed against you here in the state of Ohio or elsewhere in the next year. And I'm going to have you complete a GCPH anger management course. It's going to be a class that you're going to need to take and complete. And I'm going to have you contribute 24 hours of community service in the next 30 days on the work crew here in Pembroke County, helping, like I said, the community control, community service department, pick up litter along the street, doing various other activities here throughout Pembroke County. I'm going to issue a $150 fine plus your court costs. So that will be your sentence here today. Mr. Westbrook, anything as it relates to that sentence? Do you have questions for the record?
No, Your Honor.
Mr. Drummond, anything for the record?
No, Your Honor, thank you.
Mr. Parker, anything for the record?
No, Your Honor.
Mr. Bergman, I hope not to see you back. Best of luck, sir.
Thanks, Judge. Good to see you, sir. Thanks, sir. We tried. Yes, sir.
Since we've hit a wall, would you mind if I step back to my office for that?
No problem. Okay. I'm gonna approach and also,
Yes, Your Honor.
just so that I know which case you're here for. Sure. Sean, did you? Thank you. I just want to make sure I kept track of that. Right? She's on, here. That person's on Judge Church's. So I'll put it on record.
All right.
All right, this is recall State of Ohio versus Robert Lester. This is 2025 CRB 02147. So the record reflects that Boone is not present here today, and this matter was set before the court today for a clear trial setting. The defendant has failed to appear. There was some indication that the defendant was also on the docket for Judge Churcher here today. However, Mr. Lester has failed to appear for that hearing as well. As such, the court's going to issue a do not recall bench warrant for $10,000. The court's going to split that $5,000 between each case, CRB 1852 and CRB 2147. All right, next case will be State of Ohio versus Brittany Evans. Hi, good morning, ma'am. Are you Ms. Evans?
Yes, ma'am.
Hi, good morning. This is State of Ohio versus Brittany and Evans. This is 2025 CRB 01548. This matter is set before the court today for a clear trial setting. Let the record reflect that the defendant is present and is represented by Mr. Mason. Mr. Brown is here on behalf of the State of Ohio. It does appear that Ms. Evans has 2 complaints filed by the Miami Township Police Department for domestic violence. Mr. Mason, there is a request of the court today to continue today's proceedings. For the record, please.
Yes, Your Honor. This is our first setting with Ms. Evans, and we will file for discovery this afternoon.
Mr. Brown, any objection to a 2-week continuance in this case?
Yeah, Your Honor, thank you.
All right. So the record reflects that it does appear that this offense was filed on June 22nd, 2025. This is the first clear trial setting for Ms. Evans. This is the first time you've been brought here before this court. As such, Ms. Evans, the court is going to grant a continuance. And you heard your attorney here today indicate they're going to file a motion for discovery. You are entitled to every piece of evidence that the State of Ohio may hold that may be used against you in any type of trial. And as such, the court's going to grant that request here today. Your counsel is indicating they'll file that discovery June 3rd, i.e. today. All right, so Ms. Evans, before you leave here today, I need you to go out the doors, down the hallway, check on the assignment window. They're going to give you the due date and time for your next hearing. Most likely that'll be on a Monday because that's the day that Mr. Ferguson is in my courtroom. Just make sure you check in with them, and then they're going to give you the date and time for your next hearing. We'll see you back in 2 weeks.
Oh,
All right. Any other questions? Make sure you continue to comply. I see there's a no contact order in the file, so just make sure you're complying with any terms and conditions as it relates to your bond, okay?
I didn't know. So I do still have some belongings still there. Now, do I only go pick it up once all together to get my belongings, or as long as I keep calling authorities coming with me to grab my belongings? Like, I still have tennis shoes and everything there. I only have these careful shoes on my feet right now. I just wanted to double check. I don't want to violate anything.
But if you're talking about having a police officer, these people are with you, you can't, you need to get it together with a truck or whatever. you do.
So the way I see this, looks as though there was a temporary protection order, DBTPO issued, on 6/23 of 2025. So that is currently in order. I do not see anything as it relates to your request, ma'am, at that time to go pick up any personal belongings. I do see your bond is set at a $5,000 cash assurity bond. You are ordered to comply with all protection orders. However, there was nothing from Magistrate Graver that indicates that you had made that request at that time. Understand part of the issue that the court always is going to have to present, and I know Mr. Brown hasn't been in record yet, is Marcy's Law. And so the way I'm going to interpret the request that you're making today is a modification of your bond or a modification of the no contact order. And so the law, the Constitution now requires that the victim be notified ahead of time of any modifications to the bond because they have a right to be present in court for that hearing, maybe to object or maybe to agree. And so at this point, I'm not going to be able to make any modifications to your bond and or your no contact order because it's my understanding, Mr. Brown, the victim has not been notified of that request here today. Is that your position on behalf of the state?
That is our position, Your Honor.
And as such, Ms. Evans, understand that doesn't mean I'm not trying to hear what you have to say. Just understand that there are legal requirements that the court has to be aware of in those types of requests. Because I don't know the situation in which you've been charged. I don't know the victim in this case. I cannot make any orders that would allow you to go back to that property, even with a peace officer. Because the way I see this as it sits, you have a no contact order, and additionally, you are to comply with that no contact order. So Ms. Evans, for today's purposes, again, you'll just go out the doors down the hallway, check into the assignment window. They will give you the new date and time for your next hearing here in 2 weeks. And certainly you can contact your counsel if you believe that that's a request you want to formally make with the court. And then the court could certainly set a hearing and then the victim could be notified by the state court.
I was going to say, procedurally, what's the trigger for the prosecutor's office to contact the victim? I guess we need to file a formal motion.
My position is that you're going to need to file a motion with the court, Mr. Mason, and then the court can set that for a hearing, and at that point, the state of Ohio can notify us as to whether or not the victim is notified of the request. And go from there. Thank you.
All right.
Okay.
Next case will be State of Ohio versus Jessica Heinrich. Hi, good morning. Are you Ms. Heinrich?
Yes, sir.
You said yes, sir. Good morning, I think.
Yes.
So that's you. All right. State of Ohio versus Jessica L. Heinrich. This is 2025 CRB 01539, 2025 TRC 06985, and 2025 CRB 01538. This matter is set before the court today for a clear trial setting. Let the record reflect that the defendant is present, represented by Mr. Mason. Mr. Brahman is here on behalf of the state of Ohio. Ms. Heinrich has, looks like these 3 offenses involve a second-time OBI, a child endangering charge, and an open container charge. Mr. Mason, there is a request here of the court to continue today's matter, if you would, for the record, sir.
Your Honor, this is our first setting. With Ms. Heinrich, we're going to file a demand for discovery this afternoon.
So you're asking for 2 weeks?
If that's sufficient.
Mr. Brown, on behalf of the state?
That shouldn't be a problem.
So Ms. Heinrich, this is the first time you've been in front of this court, and so it does appear this is your first clear trial setting. So the record reflects these offenses that were alleged to have occurred on or about June 21st of 2025 in a complaint filed by the Milford Police Department. As such, your attorney is requesting a continuance today of these matters so that you can receive discovery from the state of Ohio. As a defendant in a case, you have the right to every piece of evidence that may be presented against you, and that's what your attorney is going to be filing a motion to request that information. As such, the court's going to grant a 2-week continuance in order for that to be completed, and we'll see you back here in 2 weeks. Before you leave, Ms. Heinrich, I need you to go out the doors, down the hallway to the assignment window, and then they're going to give you the time for your next date for your plea or trial setting. All right, that'll be all today, Ms. Heinrich. Thank you.
Thank you.
Sure, yeah.
Very stressful. Yeah, Samuel Acres. Drives over to Step. That's where it takes place on the front porch. It's mostly kind of deep. Mediation. This is 9:30.
Actually, it's going to be State of Ohio versus Megan Beechler. Let the record reflect that the defendant has failed to appear. It does appear that this matter was set before the court today for a 9:30 hearing on a domestic violence charge. Mr. Mason, you had contact with the defendant in this case.
Your Honor, when I arrived at 8:30, that note was waiting for me from the Public Defender Office. Apparently, Ms. Bushler was calling in because she was having difficulty getting her car to start. I'm not hearing anything else as of yet.
All right, Mr. Grumman, anything on behalf of the state of Ohio?
Yes, Your Honor, the defense advocate brought this up to me this morning. It looks like there was already a bench warrant issued today on court view.
Yeah, that didn't make any sense to me if,
You can take a look at it. I have my
See that the bond was set on May 19th, 2025. She did have 0 bench warrants at that time before Magistrate Graver. It was a $10,000 OR bond, so she was out on her own recognizance. She was working to have no contact with the victim in this case. I see no reason the bench warrant was issued post that date. I don't see anything in the file that reflects that, but
Your Honor, all I can indicate based on my reading of court view is that on 6/18, party unavailable disposition was used. And then again, bench warrant
was this a reporting bond?
filed this morning at 8:39.
she was not on a reporting bond.
So I guess I'm confused on how she could have violated before up to date at 8:30, but.
So the bailiffs indicated that that's an error on the clerk's side. Usually I assume somebody's got something in there, but as I said here, the defendant has failed to appear for a trial setting on a domestic violence case. As such, the court is going to issue a bench warrant. It does appear that she was on a $10,000 OR bond. The court's going to convert that to a $10,000 cash or surety bond, and that will be a do not recite. A registration block will issue under 1901-44. As such, the defendant will be picked up. And we brought it to this court.
Judge, if she actually was having car trouble and she came in for your 1 o'clock docket, would that be a potential recall?
Always pushing it, Mr. Mason. I would entertain the request at the time if she were to appear.
I was just going to say, I'm going to call her and I'll see if I can get her to come in.
Okay, she did have 0 bench warrants in the past, so that's persuasive to me. But if she can make it to the 1 o'clock docket and she actually appears in person, I can recall the bench warrant if there's no objection.
I appreciate it.
Next case is going to be State of Ohio versus Tasha Pierman. Hi, good morning. Are you Ms. Pierman?
Yes, sir.
Good morning. This is State of Ohio versus Tasha R. Pierman. This is 2024 CRB 03291. let the record reflect this matter is set before the court today for a reporting probation violation. The defendant is present here and represented by Mr. Mason. Mr. Drummond is here on behalf of the state of Ohio, and Officer Ledker is here on behalf of the Adult Probation Department. It's my understanding an affidavit has been filed as it relates. Actually, this is set for a sentencing on a probation violation. Is that correct?
That's correct, Your Honor.
As such, Mr. Mason, are you prepared to go forward today?
We are, Your Honor.
All right. As to, did you receive a copy of the CASC evaluation that was completed for Ms. Pierman?
I do not.
If you'd like to approach.
Sure. For some reason, it's not indicated on my file that this was presented.
Mr. Mason, I did have a note on obviously it's my job to make sure these files are being handled accurately, appropriately. Is it my understanding, Officer Ledker, and you can shine some light on this, I say sentencing, it's set before the court for probation violation, but I think what I see has happened is a bench warrant was issued on February the 25th. Your affidavit for community control violation was filed February the 25th. So I'm not sure that the defendant has been found guilty or not guilty of the probation violation. Is that correct?
That is correct, Your Honor. I don't have anything on my file indicating whether or not a guilty finding was made.
It's our intention to do an admission as to the allegations, the violations.
That's legally important, obviously, for the defendant in this court. And so if a finding has not yet been made, we're certainly not here to discuss any type of sentence. And so, Ms. Pierman, did you receive a copy of the affidavit that was filed against you on February the 25th of 2025?
I believe I was given 2 papers last week.
Mr. Mason, have you had an opportunity to show the affidavit to your client?
Yes, Your Honor. It's the same one that I just went over with you.
I have that thing back there.
Right. These violations.
Yes, sir, I do have a copy of that.
All right, as such then, what we're going to do is, Officer Ledker, if you would, please, what would you like to inform the court of here today?
Bear with me because this is a pretty lengthy spiel I have to give. I have a lot of information on Ms. Pierman, and I just want to update everything that I can to the court. Ms. Pierman was placed on probation on January 2nd of 2025. During this appointment, she viewed and signed all paperwork indicating that she understood the substance abuse policy. The defendant did indicate that she used a THC gummy the night before coming to see me on probation. Due to Ms. Pierman being on Hamilton County probation at the time, I connected with her probation officer over there, Officer Partlow, who indicated she had frequent positive screens over there, methamphetamine, amphetamines, alcohol, marijuana, throughout January and February. I was able to speak to the defendant about this behavior, and she did not seem to really give much thought to the drug and alcohol order at the time. Officer Partlow from Hamilton County ordered her into treatment in order to avoid a probation violation. But at that time, Ms. Pierman signed herself out of the treatment center within 24 hours. At this point, she became unreachable to me. I then discovered that she was incarcerated in Hamilton County for several violations. Ms. Pierman did call me about 2 weeks ago indicating that she wanted to get her classes done, which I assume she's referring to whatever she was ordered to do for the CRC. I then confronted her for reaching out to me 6 months later, as opposed to when she first had all these violations happening. She said that she did know that there was a warrant here, but assumed that I would take care of it in exchange for her attending CRC. I then called her to report in to get new referrals. However, Deputy Wells intervened in the probation lobby and did take her in on that warrant. Ms. Pierman denied CAS when she was evaluated due to the fact that she could not call her family every day. And this was the same reason she signed herself out of the treatment facility at Crossroads that she was ordered to do at Hamilton County. The defendant told the CAS assessor that she would rather stay in jail to prioritize phone time. If Ms. Pierman wants to prioritize her phone time and serve her sentence, I'm happy to go ahead and recommend that. However, if she wants to prove that she can do probation, I do recommend that she does some sort of intensive probation. She made very little progress when she was on general reporting probation. And I also want to note that she waited several weeks to contact me after being released from Hamilton County. And I believe that she minimizes her substance abuse. So she can either continue the path that she's going on or put some effort in and do some ISP. I also heavily recommend some sort of sober living because I do think that she is surrounded by temptation in her family life. And then additionally, I spoke with the defendant in holding, and she admitted to using some sort of drug she did not indicate after jail, and then last used approximately 2 weeks ago.
Thank you, Officer Webner. Mr. Mason, on behalf of the defendant here today, the defendant has put a record that she has had an opportunity to review with you the affidavit for the probation community control violation. As such, I want to make sure that we're going down each of these allegations that have been made, because I do understand that these were from February the 25th of 2025. It's my understanding, Mr. Mason, after reviewing each sanction, she violated sanction number 1, sanction number 3, sanction number 7, and condition number 3. How does your client wish to plead to the community control violation?
She admits those allegations.
As to mitigation in this case, go ahead, Mr. Mason.
Your Honor, she's 40, she just had a birthday, 48.
47.
47 years of age. Judge, she obviously has struggled with substance abuse. The Crossroads program, when she left there, as I understood it, there's quite a few things in her personal life, some people in her family that she's, I guess, basically the one trying to take care of. She can give you more details on that. As far as telling Cask that she wants to be able to use the phone, and that's why she was hesitant to do Cask, it's because of those family issues that she's trying to address. I just spoke with her. She said she actually would like to do Cask. She said she would benefit from that program. As I say, she admits that she's been struggling with substance abuse. It's just she's reluctant, I guess, to be away from her duties in the family. But if that's what it takes to get clean and sober, I think she's willing to do that now. Is all that accurate?
Yes, sir. My father just passed away, which gives me no reason at all to do what I did in February. I was trying to get into a sober living, and my probation officer was helping me, and the judge she says, she put me in jail, and I did my time in Hamilton County, and I asked for an outpatient program so that I can get the help and take care of my mother, because my father just passed away. My mother has a brain disease, and my sister is in a wheelchair. She doesn't have any legs, so she can't help my mom as much as she needs help. That was the only reason that I asked about the phone calls and said that I would be amenable to that. My mom is all that I have left besides my sister, and she, every day that I talk to her, she asks when I'm coming home because she needs help getting a shower, and she needs help, she doesn't eat because I'm not there. And I will stay clean and sober if you give me a chance to prove to you that I will stay clean and sober. I will, Miss my probation officer said that she would do intensive outpatient, or intensive intensive reporting probation, and I would gladly do that and not let you down if you would give me a chance to do that.
And as I understand it, Judge, when she failed to report on February 21st, I think, she was actually incarcerated in Hamilton County.
Yes, sir, I was. I didn't not report intentionally. I will do everything that you ask of me if given a chance, please.
And Your Honor, one thing I do want to add is when I first met with Ms. Pierman, she did indicate that she was getting some of her methamphetamines from her family members. So that does concern me if she goes and is around this beforehand.
That person is incarcerated now, and I won't be around them. It was not my immediate family, it was a distant family member, but I will completely stay away from them. And if given the chance, I will not let you down.
So Ms. Pierman, I do have a copy of the CASC evaluation, which does indicate that you refused the CASC program because you stated you would rather stay in jail where you can talk to your family daily on the phone. The indication that I'm receiving from you today is because obviously you've got, as with a lot of families, there's health issues going on with your family. And so I'm hearing one of two things here as the way that I'm seeing this. The first is, okay, we'll concede the fact that you were incarcerated in Hamilton County, which is why a bench warrant was issued and failed to appear. My concern is twofold though, based on that, which is one, I hear family members that are giving you methamphetamine, which are telling me that issue is now eliminated because that person is now incarcerated.
Yes, sir.
And then the second issue is the fact that you were, if you were to be released back out into the community, you believe you would have the wherewithal to resist using any illegal drugs, substances, or drugs of abuse.
Yes, sir.
That's your assertion here to the court today.
I promise to you, I will stay clean and sober, and I will not let you down, sir. If given the chance, the opportunity. I have power of attorney over my mom's health and her well-being because she's got a brain disease and she's just not able to take care of herself. And my mom is my main concern. That was the only thing with the phone issue and the whole program. I apologize.
You were sentenced by this court on January the 2nd of 2025, whereas you were sentenced to 90 days in the Claremont County Jail. However, the court suspended all 90 of those days, placed you on 2 years of probation. I see that out of the 24 hours of community service, you have completed 16 hours of community service. And you were placed on basic probation at that time. Obviously, when people come in here and the court has gone to the length it has to have you evaluated for CASC, and then the answer is, no, I don't want to go into CASC because of the rules and requirements within the CASC program. And we'll be honest, that typically does not go well. Okay? And so the court has to take into consideration some of the ramifications to your admissions here today. And so the court's going to make a finding of guilty to the affidavits that relates to the community control violations. As it relates to your sentence here today, I am going to make the following. So, is she being incarcerated on this particular charge?
Yes.
And how much jail credit has she?
I'm not sure of the exact number, Your Honor. I just know that she has been in since the 21st, I believe.
The jail record shows 11 days.
Yes.
Officer Leffer, has Ms. Pierman been on probation before here in Claremont County?
No, Your Honor, not to my knowledge.
court is considered for the purposes and principles of sentencing and is going to sentence you as follows, Ms. Pierman. Ms. Pierman, I am one that believes in rehabilitation. I have no doubt in my mind that you probably are a candidate for CASC. However, you denied your request to go into CASC. Additionally, I also understand you have some family issues that you're currently dealing with. And so I am going to give you the opportunity to prove all the things you just sat here and told me on the record today.
Yes, sir.
Okay?
Yes,
To release
sir.
you back out into the community on one condition.
Yes, sir.
I'm stepping your probation up from basic probation to ISP,
Yes, sir.
which means Officer Lefker is no longer going to be your probation officer.
Okay.
And now you're going to be meeting with your probation officer every single week.
Okay.
You will be tested every single week.
Yes, sir.
You are still on probation. For 2 years, you were sentenced in January, so we're talking about January of 2027.
Okay.
Just so that we're all on the same page.
Yes, sir.
I have marked in my file that if you were back in front of me, we're done having the discussion.
Yes, sir.
I gave you the opportunity to go into CASC. You've indicated you wish not to do so at this time. I respect the reasons why you've indicated that to the court.
Thank you.
But I am taking into consideration the fact that you have a fairly lengthy history of drugs of abuse. Nobody's going to sit here and tell you that getting off methamphetamine is an easy project and a process. But if there's anybody that can help you do that, it's the CASC program and it's the probation department. And so I'm just letting you know that I'm going to step you up to ISP probation. Okay, so intensive supervision. And there's a note that's been made that if there is any inclination of any issue, you stepping out of line is to be set back in front of me, and then we'll have a different discussion.
Yes, sir. Thank you very much.
Anything else for the record today, Officer Lefker?
No, Your Honor.
Mr. Brown, I didn't ask you anything on behalf of the state of Ohio.
No, Your Honor. Thank you.
Mr. Mason, for the record.
No, Your Honor.
Mr. Chairman, you're going to be released from custody here today. Take care of your mother.
Yes, sir.
Stay out of drugs. I
Yes,
hope
sir.
not to see you back.
Thank you.
Yeah. As it relates to ISP, I just want to make sure that. So when we get into one of the requirements was following recommendations of the CRC, do we have any idea what her attendance has been at CRC?
0.
Okay.
That's.
So here's another condition,
Yes, sir.
Ms. Spearman, that I'm adding into this, which is you are required to complete your assessment with CRC,
Okay.
and you are required to follow their recommendations.
Okay.
Okay, so those are going to be the two things that you are going to be penalized with here today, which is stepping up probation for you to demonstrate to me that all the things you just told me today, you're serious about. And number two, you were ordered to complete and follow all recommendations of GCBH and CRC. I'm giving an inclination here that you haven't completed any of those things. So you walk out of here today knowing that that's something you need to follow up with your probation officer, because you'll be meeting with him once a week. But you need to complete the assessment and you have to follow their recommendations. Do you understand that?
Yes, sir.
Right. As it relates to your time on intensive supervision, again, you are not to use any alcohol, drugs, illegal drugs, that includes marijuana. You are not to enter any establishment whose primary source of income is derived from alcohol sales. Again, you have to successfully complete the substance abuse treatment at GCBH and follow their recommendations. Additionally, I need you to complete any counseling that your ISP probation officer may assign to you. If sober support they believe is going to be helpful to you, that's something you're going to be required to do. You have shown me some ability to complete your community service. You were ordered to complete 24 hours. You've completed 16 hours. You need to complete the remainder of your community service. And again, follow the recommendations that have been outlined here to you today based on your sentence. Spearman, you will be released from custody today. I wish you the best of luck.
Thank you very much.
And if I see you back, we'll be having a different discussion.
Thank you very much.
Thank you, ma'am.
Yes, sir. Thank you, Judge.
These guards are in, I'm going to talk with them. I think we're continuing this better.
welcome, sir. Okay. State of Ohio versus Brandon Ray.
Good morning, Your Honor.
Good morning. Are you, sir, Mr. Ray?
Yes, sir.
Hi, good morning. This is again State of Ohio versus Brandon K. Ray. This is 2024 TRC 055551. Let the record reflect that this is set before the court today for a motion for driving privileges, or I should say an amended motion for driving privileges. The defendant is present, represented by counsel Mr. Dinslow. Mr. Drummond is here on behalf of the state of Ohio. It's my understanding today you filed that motion. Mr. Dinslow, it's your motion. Take it away.
Thank you, Judge. Your Honor, we initially filed a motion to terminate the license suspension. It's a 2-year suspension. It's been in place for about 13 months. That motion was denied. And so we filed to amend his driving privileges. And what we're seeking today is to have the ignition interlock device removed. He's had it on there for over a year. At the time of sentencing, with Judge Craming at the time, he indicated that we could come back after a period of time and request to have it removed, and he would likely do so. I think we tried it 6 months, that was denied, so we're here again after a little after a year to try again. I think one of the big reasons he wants it removed, obviously it's a challenge interacting with that thing, but maybe more so, his son just turned 16, got his temporary license. He'd like to be able to teach his son to drive, let his son drive his car during this period of time. And with the device on the car, it makes it very difficult. It's a big distraction.
Thank you, Mr. Dinslow. Mr. Drummond, on behalf of the state of Ohio.
We'll defer to the court, Your Honor.
Mr. Dinslow, you're indicating that there have, I see a couple of examples, August 26th of 2024, that there was an interlock tampering and or lockout. I saw that the defendant was ordered to screen the device for 60 days. Is that your understanding?
That's my recollection, Your Honor.
Additionally, I see you appeal the violation of motion to reconsider the 60 days of alcohol monitoring, which there was a decision issued on September 12th of 2024 denying that request.
Also correct.
You then filed a motion to vacate that hearing for November 19, 2024. And then there were driving privileges requested on November the 19th of 2024, which was denied. Then you filed a separate motion May 30th of 2025 to mitigate, to request hearing, which was also denied. The grounds for that request at that time were that he's a full-time employee of Cincinnati Children's Hospital and then the long-term assistant football coach at Archbishop McNicholas High School, and he was requesting privileges based, I guess, on those two grounds. This motion was set for hearing by June 12th of 2025, and that's what we're here for today. Is it your understanding that there have been no issues with the interlock since back in 2024?
Your Honor, actually, my understanding, there was an issue this weekend on Saturday. You want to explain that?
Yes. So there was.
That means it hasn't gotten to me yet, but it's coming.
Well, I stopped at the probation office and had them double check.
Okay.
And I did, the first time this happened, short version, I went and got a urine test. I was not drinking, I'm not drinking. We believe it was, I'm a type 2 diabetic that's now becoming type 1. So I'm starting to intake sugar more than I'm used to. I was drinking kombucha. And I think that's what caused me to, but I went and had a urine test on and showed that I did not have alcohol. This past weekend, I did what I was supposed to do, what the probation officer told me to do. If it ever tripped, rinse your mouth out, wash your mouth, wash your hands. I did that, and it immediately was negative. I believe it may have been caused from what I ate. I had tried some homemade mulberry jam that it didn't cancel. It was given to me by an elderly family that we take care of.
How much time passed between that?
Maybe, first was maybe 2 minutes, if that, enough time for me to run in, rinse my mouth, my hands, my mouth, and come back and do it. And he checked, went online, said there was no concern with the probation officer.
Who is your probation officer?
It is, remember her name? Ashley Jameson, but she was not there, and it was the gentleman, I don't know his name. He sits right in front of her, he took me in there and took a look at it, and then we talked in the hallway. He didn't think there was anything to be concerned with, and I told him what I was going to court today.
So besides August 23rd of 2024, and then up to today's date over the weekend, those are the only two issues you believe you've had on the interlock?
Oh, absolutely. I go to my check-in, I'm never late, pay my bill, I have not touched alcohol. I'm actually never going to drink again. I've sworn off alcohol. Not just because of what's happened to me and that decision I made, but what I've seen, just in general, how ingrained alcohol is in everything you do if you don't drink.
So your driving privileges as they're currently outlined today, Mr. Dinslow, can you put those of record? Is it my understanding that's based on the original sentence from Judge Greenwich?
Yeah, that's correct, Your Honor. I think we've got work privileges, court, probation, medical, child-related responsibilities, including school and extracurricular activities, and then a 4-hour window on Fridays from 4 to 8 to take care of personal necessities.
Yeah, that's correct.
I'm going to do, Mr. Reyes, I'm going to take this issue under advisement. As such, I'm going to contact the probation department to make sure that everything you've demonstrated to me here today is true and accurate. And the court can then make a decision based on your request to remove the interlock device from your vehicle. Mr. Dinslow, I know driving privileges are a frustration. Every court, I think, handles those differently, and that's because the discretion is at the trial court. And so, typically, just so you understand, for me, within 6 months of the expiration date is typically when I would take a look at the removal of the driving privileges and allow it to be 24/7. Interlock is kind of up in the air. Obviously, the legislature just changed a lot of that on April the 9th of 2025. But I just wanted to give you some guidance so that you understood kind of at least my thinking when it comes to some of this. And so I would entertain termination of limited driving privileges, but typically that's going to be within 6 months of the expiration by the sentencing judge. I consider this to be a truth in sentencing issue. I get a motion for driving privileges 3 weeks after I sentence somebody, and that is not truth in sentencing. If that's the sentence of the court, that's the sentence of the court. And so I just want to give you that bearing so you understood it typically, because I say he's going to be suspended. I didn't look to see if that was suspended back to the date of the offense.
It was.
Okay, so the date of the offense would have been
May 11th.
Yeah, May 11th of 2024, so you're looking at obviously May 11th of 2026. But I'm going to take into consideration your request that's been made here today. Once I talk to the probation department to make sure that everything you told me here today is accurate, I'm leaning towards granting the request.
Wonderful. Thank you, Your Honor. Could we add one additional little tweak to the driving privileges?
Oh, I'm sorry. I had a question.
Son turned 16, as I mentioned. He'd like to go take him out to drive. Is that okay? Can we add that to the privileges?
So we'll get into the principal issue of that. Obviously, I assume you're going to instruct Mr. Ray how you drive a car, what you drive a car, what you don't do while you're driving a car.
Exactly.
Right? That's going to be part of the instruction.
Oh, it's, as a coach, as a parent, trust me, everyone that comes across knows what I did. I use it as a teaching tool. I'm not trying to
I mean, I have no opposition to you teaching your son how to drive as long as what I'm saying to you is your intention.
Absolutely.
Now, the problem with having limited driving privileges is that's gonna have to be kind of set on a schedule to some extent.
Right.
I have to put something in there, because if you get pulled over and it's outside the time that I've given you, you're gonna have a bigger issue.
Right.
Which is you're driving under an OBI suspension. That's mandatory jail time.
I know.
So, having a child that goes through these things myself, I understand. You would anticipate a certain day of the week or a certain time that you would want to be able to take your son out to learn how to drive.
It would typically be a Monday, Wednesday, or a Friday. He plays football where I coach, so based on their schedules, they do things in the morning on those days, so I can take him in the afternoons. Some of that would be determined on my work schedule as well.
Here's what I'm gonna do, because I don't wanna get into that. I'm just gonna allow you to be out teaching your son how to drive now. The issue that I have with that is I can see that being used as an excuse if your son was in the car and you're pulled over.
Yeah.
And you're just gonna say, well, I'm out teaching my son how to drive. And so when is your son supposed to take his driving test?
Where he's finishing up his,
Online.
the online thing, and then we have to call the,
Yep.
and so depending upon their weight, it'll all depend upon the.
He has to drive so many hours.
Right, so
Right.
it'll 100% depend upon that, when we can get him into the actual company. So I envision it probably being 2 to 3 months, would be my guess, based on the weight
Yeah.
that our daughter had.
I'm guessing probably 6 months. He hasn't driven at all. And he's a little frustrated.
I'll add a provision into your driving privileges, Mr. Ray, assuming that the court grants your request to remove the interlock. Otherwise, this issue still needs to be addressed, even if the court doesn't allow interlock to be removed. And so I will allow you to have driving privileges with your son for driving instruction purposes. Again, I will set that because they're only allowed to drive so many hours a day. So I don't want to make an order today. I'm going to go look at the driving requirements to see how that's set, and then I'll provide a schedule to you on when you're going to be permitted to entertain that request with your son. And it will be limited to some period of time, a matter of a couple of months, probably 3 months at the most. All right. And then I anticipate Mr. Dinslow being back in here probably around December with a separate request, assuming all has gone well, based on the sentence that you received from this court back on May 28th of 2024.
Yes, sir. Great, thank you, Judge.
Thank you.
So,
No.
Put that on my desk. Next case is the State of Ohio versus Quincy Young. Hi, good morning, sir. Are you Mr. Young?
Yes, sir.
Hi, good morning.
Good morning.
This is State of Ohio versus Quincy H. Young. This is 2025 CRP 01550. This matter is set before the court today for a clear trial setting. Let the record reflect that Mr. Young is present and is represented by counsel today, Mr. Mason. Mr. Brown is here on behalf of the state of Ohio. Mr. Mason, it appears that there is a request of the court today to continue today's hearing. Go ahead with your request.
Your Honor, we're asking to go ahead and set it for a bench trial. We will file a discovery demand this afternoon. Your Honor, as far as bond, I've explained how Marcy's law works. From what I understand, this gentleman's fiance, who's here in the courtroom, she tells me she actually saw a screenshot. The alleged victim is her 27-year-old son. She actually saw a screenshot of where he apparently was communicating with our prosecutor's office, saying that he didn't want to go forward with prosecution. And you don't have any notes on that, correct? So I'm assuming you can't modify the bond today. We can go ahead and file a motion requesting that.
Mr. Brown, on behalf of the state.
Your Honor, I believe they're required to give us notice about a potential bond notification. We have not contacted the witness or never have their input, so I now is not the time to address that.
All right, so let's do one issue at a time. So as it relates to the request for the continuance, Mr. Mason, I heard you ask for, there was something you said in your statement that concerned me. The first is you're asking for a bench trial, but then I think I heard you say you haven't even filed for discovery yet.
We haven't filed that this afternoon.
So that's kind of a two-pronged issue, really. So are you asking for a 2-week continuance in order for discovery to be adhered to, so you have a chance to review the discovery with your client prior to it being set for a bench trial, or you just want the court to set it for a bench trial?
Well, I want to set it for a bench trial. We are going to file the demand for discovery. If he was out on bond, I would set it for 5 weeks down the road, but because he may not have his bond modified, we want to set it as soon as possible.
Mr. Brown, you've had an opportunity to hear some of that today. Do you have the discovery from Miami Township? Are you going to be, I guess my question is, you're going to be able to comply with that in a fairly quick turnaround time if Mr. Mason were to file that request today?
Yes, I am today. I can probably get some by the bond.
Yeah. And that's fine, Your Honor. We understand the time constraints.
Well, I just don't want to be here for a bench trial and then the problem is, well, discovery, there's more discovery, or there's discovery that wasn't anticipated. And so this is a fairly new case. That's my concern, is this was just filed on June 22nd. You're asking for a bench trial and you haven't even asked for discovery. And so are you asking then for 2 weeks to set this for a bench trial?
Yeah, I don't think we can set it any sooner than that.
Any opposition to the request for the continuance?
Sure.
As it relates to this question related to bond, Mr. Young, I'm sure your attorney has made you aware. It appears that the magistrate set your bond at $20,000 cash for surety. I do see you had some history with bench warrants with the court. So the court is in the position to be able to entertain a modification of the bond because the victim in this case does have the right to object to any modifications. As such, they have to be notified of today's hearing, and so they were not notified of today's hearing because this is set for a plea of trial setting. As such, your counsel is going to be accurate. My position on these matters is I'm not going to entertain the request to modify a bond today. However, if there's a formal request filed with the court can set this for a separate hearing to entertain the request for bond. I assume you also understand that you would be able to post bond with a bail's bond of your choice for $2,000.
Yes, sir.
Okay. All right. All right, very well. And I understand that that can be a financial constraint as it relates to being able to be released from custody. As such, the court's going to grant the continuance for 2 weeks, which I consider to be as accelerated as the court can probably make that happen. Additionally, I have to make sure, Mr. Graham, I know you're still new to the prosecutor's office, but it's been the last couple of months, that they're requesting at least 3 weeks in order for the sheriff's department to issue subpoenas. So I just wanted to make sure I'm making a record of that that's a consideration in this particular case. I don't know who the state may be calling, I don't know who the defendant may be calling, but I know that, it's not unusual for the state to be requesting 3 weeks to be able to get the subpoenas issued through the sheriff's department. So I can set it for 2 weeks as long as it's.
Your Honor, I had a same question, so I'm in the process of tracking down that answer. He's talking about those issues, but if that's typical delay time, we would ask for 3 weeks.
And I'm looking and I see it's Officer Ryan from Miami Township. I don't know what his schedule is. You don't know what his schedule is. And so, why don't we do this? I'm going to set it for 2 weeks at the request of the defendant. And if for whatever reason that there's some issues with that, then we're going to have to address that at the time of the bench trial. Anything else for the record today on this case?
No, Your Honor.
Not much, Your Honor.
All right, very well. Mr. Young, I will see you back here in 2 weeks. Your attorney is going to be filing discovery today. The state has indicated that they will comply with that request fairly quickly. And then we've got this set for a bench trial on an accelerated calendar. We'll see you back here in 2 weeks, sir.
Yes, sir. Thank you.
Thank you. Ma'am?
Can you go to the conference room just for a second? I think you need some information from. Sure.
All right, you're off the record. Court is adjourned.
Thank you, Your Honor.
We'll see you back at 1 o'clock.